All right. Thanks for joining us today. We're going to jump into things. Every week we talk about estate planning and some of the strategies and some of the things to be aware of related to planning for your legacy and your future and your estate. And today we are talking about some of the basics of estate planning, and specifically, what's the difference between having a will and then having a trust? A lot of times people will come to us, and I've had, by the way, other attorneys that practice in other areas of law, medical doctors, OBGYNs, chiropractors, lots of different kinds of professionals that come to me, and they have very complex, sometimes very large estates, and they'll say, oh, well, I just need a simple will. And the problem is that, the public a lot of times doesn't know what the advantage of having and what the purpose of setting up this sort of structure would be. And so the assumption is that a will be fine for whatever their needs are. And a lot of times it's just not the case. So the biggest difference between a will and a trust are two things. Number one, a will is what we call a testamentary instrument. That means that it doesn't do anything until after you pass away. So the will becomes effective at the point that you actually kick the bucket, right, when you pass away. And then in order for your will to have any validity, for it to be followed, the second biggest difference is that it has to be validated through a court of law. That court is called a probate court, and every state has a probate court. And the idea of the probate court is that they want to confirm that the information on the will is valid, and then they will follow what your will says. But a lot of times, if you go into the probate process, it's very simple for anybody to contest things because they're already in court. They don't have to pay any money out of pocket to be represented by an attorney or anything like that, and they can contest things very easily. And so, most people prefer to avoid the probate process if possible, because probate can take a long time. It can cost a lot of money. It can cause a lot of stress on the family. It's a public process, right? We'll talk more about it in just a little bit. But probate is one of those things that it's a necessary evil for the court to be able to validate and follow what's in your will. So if you just have a simple will, your will, first of all, will not protect you until after you pass away. And then second of all, will have to go through the court system. It will have to be probated in order for it to be valid and be followed. If you do not want your will or your estate plan to have to go through that process, then that's where a trust comes in. And there's other ways, which we'll talk about in just a little bit, that also can avoid probate, can avoid, the need for a will. But if you want to avoid probate in general, especially when you have children and you have real estate, we recommend using a revocable living trust. So again, back to the two differences. The first difference is that a will is a testamentary instrument, but a trust is a living document. So we call it a living trust because once you set it up, it starts protecting things immediately while you're still alive. And in the case of incapacity or in the case of some sort of emergency, maybe you get stuck outside of the country or something like that, then, it will still start protecting things and you can have somebody manage things on your behalf. Whereas the will only do that after you pass away. The second difference is if you have a will, your will has to be probated in order for it to have effect. And if you have a properly structured trust, your trust does not have to go through probate. In fact, it's very unlikely that somebody's going to contest a trust, because when you set up your trust, you also set up who your successor trustee is going to be. And the trustee is kind of like the manager. They get to manage everything that's inside of your trust on your behalf. If you set up your trust yourself, most of the time you're going to be the trustee as long as you're alive, as long as you're able to. But if there comes a point where you're not able to, you're no longer able to, then your successor trustee is going to step in, and that process is a very smooth process. It can happen more or less automatically. There's no need for them to go through the court system to have to do that. And if anybody tries to contest the trust, the trustee is empowered to protect the trust with the assets of the trust. So whatever you leave behind, that's actually going to be earmarked according to the trust to be divided out or distributed according to the terms of your document. And your trustee is empowered to use those assets to protect the interests of the trust. So if somebody disagrees with how you divided things out or what you said in your trust, they're going to have to fight it themselves, and they have to go hire legal counsel, and they have to pay court fees, and they have to, try to contest things. And knowing that your trustee is going to be using the assets of the estate to protect the document and to protect the integrity of your plan. And so it's very unlikely that somebody's going to ever contest your trust, whereas with the will, it's a lot more likely because you're already in the court process, in the court system. So let me share with you just kind of two examples of this. One is when you have a will, again, they don't even have to disagree with your will in order to contest things or slow things down a lot of times. And it depends, obviously, on what state you're in, and the laws of probate for each specific state vary somewhat. But at the end of the day, if you have a probate that's open and one of the siblings or one of the interested parties does not respond in a timely manner to the acceptance of the personal representative, that's kind of like the equivalent of a trustee, but for the will, right? They're the person that the court's going to appoint to be in charge of managing the estate, assuming that you get to that point. If they just don't respond to the notices or they don't give permission in a timely manner to the court, that by itself can slow down the process. So they don't even have to disagree with your will in order to slow down the process. And sometimes that causes a lot of stress and heartache on the family, right? So we had a situation where unfortunately the mom and dad had passed away and there was no will. And so we're in the probate process, and one of the siblings was supposed to be appointed as personal representative. All the other siblings agreed to it, but they didn't respond in writing quick enough, right? So there's 3 kids. 2 of them had submitted their the notices that we had asked for, and the 3rd one had not submitted it yet. And it was only like 3 days. Like, we had sent it on a Friday, and we were talking like on Monday or Tuesday, right? And so the sister asked, well, did you get it back from everybody? No, we only got it from you and from your brother. And then she starts saying, well, of course my sister didn't send it in. She's probably talking to an attorney and going to contest things. She's probably lawyering up, right? And she's probably wanting to get more out of the estate because that's just how she is. And I said, well, just wait a minute, right? It's only been 3 days. Let's give her a week at least, right? Maybe she was out of town. Maybe she's on vacation. Maybe she didn't see the email. I mean, there's lots of reasons why maybe we haven't gotten this back yet. And don't be impatient, right? But immediately the emotions get high. And it was slowing the process down. And so they were, upset with that. But sometimes, things can blow up, not because anybody has ill intentions, but just because the probate process can be a stressful process. And another reason why a lot of times people want to avoid it. Now, let me give you another example. We had a trust that we didn't establish. Somebody else had established it, another attorney, and, the mom had passed away. She had left the trust in place, but unfortunately had not funded the trust properly. So when you have a trust plan, you need to make sure that your assets are owned by the trust. If they're not owned by the trust or they're not pointed to the trust with beneficiary designations, then your trust will not be effective to avoid probate. So every trust plan has what's called a pour-over will, and your pour-over will basically save the plan, make sure that it still is effective, that the trust will be followed. But what the pour-over will does is it says anything that wasn't in the trust now goes into the trust. And what's the problem with the will we just talked about? The will has to go through probate. So now your pour-over will, it's a very simple probate, but it's still probate. Your pour-over will has to go through probate and then put the assets into the trust. Well, in this situation, one of the family members wanted to contest the trust. And we explained to them that there's nothing to contest. There's no reason for them to, be able to contest it. And there's 3 potential ways that somebody could contest a trust. Number one, they could say, okay, well, this trust was invalid because it wasn't structured properly, right? If you work with a good attorney and they help you to do your trust plan, it's very unlikely that that's going to be the case. The second potential challenge to a trust is, well, when my family member, whoever, when they signed this, they weren't in their right mind. They didn't have capacity. So whether it's a trust or a will, testamentary capacity is a very low standard to reach. Basically, they have to know who they are. They have to know more or less what they own. They have to know who the natural objects of their affection are, right? So who's friends and family, right? If they can do those things, then they probably had capacity to be able to sign their will or trust. So it's very high standard to try to contest a trust on those grounds. And the person that's contesting it has to have the evidence showing that that's the case. They can't just allege things and then the court's going to just believe it, right? It doesn't work that way. And then the third potential challenge to the trust is what's called undue influence. So somebody, twisted mom's arm to sign the trust, or they put some sort of, threat or pressure on her to execute her trust plan. And that's why it says what it says. And if there's no evidence, again, the person challenging it has to present the evidence. If there's no evidence to that effect, then it's very unlikely that that's going to go anywhere. And so, again, anybody challenging the trust has to pay for those costs themselves. And it's very unlikely, because there's no incentive for them to do that. So most of the time, trusts don't get challenged and they don't have to go to court at all. And it's very rare, extremely rare, that we ever see a trust that actually has those issues where it gets challenged and where we have to, worry about it. So the other thing is, the difference between your will plan and your trust plan, and when would one be appropriate and the other, or the other be appropriate? We basically will recommend that when somebody is married or has children, then that's really kind of the benchmark where you start considering, okay, I need a will. Or maybe you're not married and you don't have kids, but you have significant assets, right? In most states, if you're over $100,000 in value in personal assets or personal property, that includes, bank accounts, savings, retirement accounts, those sort of things, then you have to go through a probate process if something happens to you. But if you have beneficiary designations on accounts or on assets, then those pass outside of probate. They're what we call non-probatable assets. So you can get away from the need to have to go through the court system through probate if you have somebody designated on your account that if something happens to me, then this person, my wife or my kids or whoever, this person's going to get the assets in this particular account. And they're going to be able to, use it and benefit from it. And that will happen more or less automatically as well, because it's under contractual law and you've designated a beneficiary. Same thing with life insurance, right? Your beneficiary on life insurance, they get it without it having to go through probate. However, if you're above those amounts on any assets that either maybe you didn't designate a beneficiary, there's a failure of beneficiaries, or didn't have the opportunity to put a beneficiary on it, right? Then that's going to be exposed to probate. And so we recommend that you have, a will if you want to specifically state how things are going to be divided and not leave it up to your state intestacy laws, right? But once you have children and you have real estate, or once you have children and you have over 100,000 or so, depending on the state you're in, then that's when we recommend the trust, because then that's what's going to help you avoid the probate process. And in most states, again, there's the minimal amount that you can avoid probate if you're under that amount, at least a formal probate. There's an alternate process that's easier to kind of go through that you can avoid if you're under that minimal amount. But if you have real estate, no matter what the cost is, then you will still have to go through the probate process. And so that's where we recommend having your revocable living trust. We had a client that came to us and they said, I don't think that we need to do a trust because we just have a mobile home. And so, if mom dies, the mobile home's worth $30,000. It's under the, $100,000 limit for the state that they were in. And so they're not going to have probate. And I said, well, what kind of mobile home is it? There's two types of mobile homes. There's, mobile homes that you actually own the land that the mobile home is under or is sitting on, right? And then there's mobile homes where you own only the structure, you don't own the land at all. And so if it's just the structure, then it's a personal property interest. And if it's, the actual land, then it's a real property interest. So that means that they're treated differently. In this case, it was a real property interest. And that means that if mom were to pass away, the mobile home would have to go to probate. Even though it's only worth $30,000, doesn't matter. It's still subject to probate because it's real property. It's real estate interest, right? And so we recommended having a trust. Otherwise, they'd be exposed to probate. So when you have land, real estate, a home, anything like that, then that's kind of the benchmark for really needing to look at a trust plan. On a minimum, having a revocable living trust plan, right? And again, back to the beginning where we talked about attorneys, doctors, other professionals that sometimes think they just need a simple will. The reality is that they probably need a more complex plan, even beyond just a simple trust. But again, unfortunately, a lot of times we just hear, I just need a simple will. In reality, they need a trust, and sometimes they need a lot more than that. So join us in the next few weeks. We're going to be talking about, more in regards to planning for incapacity and planning around business interests. If you're a business owner, we have this podcast, this recording, Clubhouse meeting every Thursday. And we invite you to join us next week or to listen to us wherever you get your podcasts. So at this point, if we have any questions, anybody that wants to pipe in or submit a question, feel free to raise your hand. We'll try to unmute you, or you can send it through the messaging here. All right. One question that was submitted here is if you do a will, does that cover both spouses? And the answer is your will is a personal document that is only for you. So if you're married, you will need a will and your spouse will need a will as well. But if you do a trust, oftentimes, most of the time, you would do a joint trust. So you only need one. Your joint trust would cover both of your interests, and whatever you put into the trust, right, would be covered. And when you do your trust, you're still going to do a will. It's a pour-over will, and you'll each have your pour-over will. Yeah. All right. Any other questions? Well, thanks again for joining us. We hope that you found some value in spending a few minutes with us this afternoon. And again, join us wherever you get your podcasts or look for the recording on YouTube. And we'll look forward to talking to you all soon.